strip, yeah, I know she can't hold it. Looking on your bitch, even though she got COVID.
Reflect, champs.
Reflect.
Reflect.
So I'ma have to put you on timeout, sit Indian style, let you stare at that nice wall in your mother's basement and reflect, champ.
It's time to take a time out and reflect, champs. While you're sitting Indian style and you're looking at your grandmother's wall in that basement, make sure you take time to reflect, champs. And while you're doing all your reflecting, make sure you go over to wearetough.com and get your merch today. That is wearetough.com. And get your merch today. Today. What you talking about?
Welcome to Showface News. You can call me what you want. Just don't call me woke. We live again with another one. Salute to the sniper gang. Salute to the chat. Listen, let me explain something to y'all. Y'all know a nigga just don't be taking breaks or nothing like that. I didn't take a break at all. They tried to knock a nigga channel down. That's what they tried to do. You know they tried to get the real nigga up out of here, man. They tried to get me up out of here. They tried to take the channel down. And guess what? Whoever took the channel down, I want you to know there's consequences for what you did. And I know exactly who you are. So if you think that I don't got the connection or the plug, I want you to know that there's consequences for that. Respectfully, you're going to see. There's going to be a lot of reflection going on this summer. Respectfully. Salute to the chat. Once again, we back. We back, man. And I'm here to stay. You dig? But look, man, make sure y'all smashing that like button and subscribing to the channel. Look, man. So we got this whole Young Thug thing going on, man. Young Thug is having his bond hearing as we speak. A lot of people are saying that Gotti told on YSL, and that's absolutely false information. Gotti did not tell. Gotti gave the police fake information to throw them off. So Gotti is not a snitch. That's not factual. A lot of niggas be jumping the gun, man. But let's get right into this, man. This is the Young Thug bond hearing. Salute to the chat once again. We are back with another one. Things is about to get crazy. Let's get it.
Other things that I believe are necessary for me to make a bond determination.
Your Honor, to start, I think you should know my client is 29 years old. He completed high school. He is a full-time musician. He's signed to a nationally recognized recording label. He's had 1 platinum and 2 gold records. Your Honor, he's got a child who is 7 years old, Dawson, who he helps to raise with that child's mother. He's lived in Atlanta his whole life, Your Honor. He has significant ties to the community. His mother, Tasha, is here. You'll just stand up, Tasha. And there are a lot of friends and family and people here from the community in support of him. If you'll hear on behalf of Mr. Kendrick, just please stand up. So, Your Honor, he's got a lot of community support.
Thank you, ladies and gentlemen. You can sit down.
He's got friends, family, business associates. He's really, I mean, other than for work to perform as a musician, hasn't really left the state of Georgia. He's got significant ties here. He's lived here his whole life. And there are, and Your Honor, if there's a way that I can display these to the court, or I can just enter them, if we're doing this, I assume we're doing bond by proffer today. So,
Do you, Mr. Geary, do you have any objections to what have you seen what Mr. Apt is showing?
I view them no objections.
Okay, all right. And you can just hand them to me if you have a copy for me.
I do, Your Honor. And
Okay.
so,
All right.
what I'm, in, if Your Honor is okay, I'll just
I'll admit your, okay, so we have 1, 2, 3, 4, 5, 6, 7, nine photos. I'll admit them as D1 for purposes of the motion, okay?
Thank you, Your Honor.
All right.
And so what you're looking at are photographs of my client in various philanthropic and community service organizations. He helped create a youth football team to help inner city youth stay off the streets. That is known as the Atlanta Trackhawks. He helped found that organization. He coached those kids. He created this youth football league, which is actively involved in order to ensure that young inner city children are doing the right thing, learning the right ways in life, and having an outlet. He also is involved in a other charity called Area 51, which there is photographic evidence of, where he helped raise money for and provide food for underprivileged and inner city families and homeless people. Your Honor, you'll also see in those photographs, there are charity concerts my client has done in order to raise money, where he did, took all the proceeds of those concerts and used those funds to provide the food and football equipment and other means by which he supported the community. Now, I expect Mr. Gary to raise that my client's had some criminal history, and we don't deny that. But I think what's telling about his prior criminal cases is that he has shown up and appeared for every single court date, every time, both in state and federal courts, when he was charged with crimes that could have cost him his life. He does not have failure to appears. He is not a flight risk. And I would present to the court, he had even another murder case in this very courthouse in which the state declined to prosecute him. And he showed up for every court date. The state has a habit of wrongfully accusing my client of these serious crimes. And they're going to try and argue that he's been arrested previously for other crimes, several of which he was not convicted of. But he's got community support, Your Honor, as I'm sure Your Honor would expect in a serious case like this. We'd be happy to have him on house arrest and have an ankle monitor on him and provide the state and the court with a list of approved visitors, which the state could have the option to edit and change. And the only reason we'd really want him to leave the house is for a medical emergency. I can go to his residence and he can assist me in his defense, or I can meet with him by Zoom. But I do believe that the court should consider a reasonable bond in this matter. He does have ties to communities. He's not a flight risk. We'd be happy to turn over his passport. And I think we are humble before the court in asking that the court issue a bond, cash property, or surety of good bond of $100,000. Thank you, Your Honor.
All right, thank you, Mr. Abbott. Mr. Gary?
Good morning, sir.
Good morning.
Judge, I'm not going to belabor the record that the counsel went over. It is extensive. I will say in one of the incidences in a federal court, which you'll hear more about probably later in a hearing today, Mr. Steele actually represented Mr. Kendrick in a probation revocation in federal court. So apparently he doesn't do very well on probation. For the court's knowledge, and I guess I'll start and go a little backwards, while Mr. Kendrick has been in court, we have him documented to using another inmate's phone messages or phone code to use the phone at the jail to try not to be discovered. In some of the phone calls, that we had concerning Mr. Kendrick. He's actually trying to get a phone brought to him in the jail. And we actually are aware right now that he actually has a phone in the jail, or had recently. He may not have it right now, that he's been using that cell phone at the jail. So he's not working very well now. At the time of his arrest from the indictment, he actually fled the house. He was stopped back in the woods, so he tried to flee then. He has 10 new open charges as a result of that arrest. My understanding, he's on no bond from that already. And that's just on the recent things, Judge. Judge, he has a murder charge in Acts 17, 18, and 19 of the indictment that's pending in this case. He's also been, and that's again a murder charge of Mr. Donovan Thomas. Judge, he's also been convicted in Act 56, which is a conspiracy to commit murder, to which he actually confessed to. And he and another individual on this indictment were found with a fully loaded AK-47 and a .40 caliber handgun. They just happened to make a traffic violation before they got to where they were going, and they were stopped by police and the weapons were located. Judge, he has been active throughout the pendency of this gang. He is active now, continues to be active. When we've got him on the phone, the cell phone from the jail, he is continually speaking about gang activity to the extent that he's even trying to hide evidence. There were cell phones located at a particular area, and he called to make sure those phones were disposed of. Given that we were on that call, we located those phones before they could be destroyed. So the attempt was made. We just happened to be lucky enough to be one step ahead of him in that situation. He's got a prior, to my understanding, in the attempted murder case also of a gang charge, so that's documented as well. In the conspiracy to commit murder charge, they also had a stolen weapon, which is very common with this outfit. They have numerous stolen weapon allegations throughout this. They don't use weapons that respectfully are traceable back to any of them. During that time, he was a convicted felon, so he's got also a conviction for possession of firearm by a convicted felon. So he clearly doesn't listen to court's instructions as given to him. He is in a music video, and I know we've had some back and forth on that, but that's as late as 2020, where he basically said that if people mess with one of the other gang members, they're going to die. In 2020, he also, and I think we've spoken to this before, he saw YFN Lucci in a mall in the Atlanta area, went out and was photographed standing on top of his car, and that was released on social media to antagonize a rival gang. And that was that was 8/11 of 2020. Your Honor, we've got other numerous videos and photographs in the indictment showing the defendant posing for these things and involved in these things, demonstrating a allegiance and a loyalty to the gang and the gang activity, to including violence and other types of gang activity. Given that, I would say that he is a pending murder, that he's already pled to an attempted murder, that his conduct has showed complete disrespect to the court's orders prior to having a weapon by a convicted felon, and while in jail, attempting to circumvent the jail call process and to get a cell phone in, which he was successful in doing, and talking about destroying evidence in there while doing that. Your Honor, I would say he is an extreme threat to the community, to witnesses, and to commit additional felonies, and ask the court to deny bond.
Your Honor, may I briefly respond?
You can, sir, go ahead.
So, the first
Fight
thing I'd like
back,
to
nigga.
address
Fight
is
back.
Mr. Gary categorizes my client as having been previously convicted of and pled guilty to allegations in this indictment, which is, I don't know whether Mr. Gary is just having a.
That's the predicate, I think, or that's the allegation as part of the indictment in one of the counts. I think that's what he's referring to.
Your Honor, he has not pled guilty to any underlying. He's been convicted of one federal gun offense and has a probation violation from that offense. Those are his convictions. So if the state wants to allege that that is the basis for their charge that he's a convicted felon in possession of firearm, they're allowed to do that. But to say that he's been already pled guilty to and convicted of counts in this indictment is a gross misstatement. And Your Honor obviously knows that my client's presumed innocent. That's the presumption he carries with him at this very hearing. The state wants to allege that he fled the home at the time of his arrest. He was a visitor at a friend's home, who's a co-defendant in this case, and there were an army of people approaching through multiple directions towards the house. And at that moment, at that particular moment, he did not know that there were police, that they were police, and that they were there.
He didn't know that those was the boys. Come on, Dad. What are we doing? Look, I get it. You try to defend your client, but come on, nigga. Come on, Chad. Look, there was an army, and they were coming on both directions of the house, but he didn't know that they were police. There's no way, Your Honor. There's no way. Come on, fam. he didn't know. He didn't know this. Come on, you gotta do better. You gotta do better. You gotta fight. You gotta fight back a little tougher, fam. This ain't looking too good right now. This ain't looking too good. Respectfully, Chad. You did? No reflections yet. Y'all. There's a lot of, good behavior in the chat. Niggas ain't been wilding just yet. Let's proceed, y'all.
There to arrest him. All he knew is there were armed men approaching the house. And so, yes, he ran for his own safety. Once he realized there were police, he returned and he was arrested. There is a photograph of my client standing on a car. That's about the best evidence the state has. Hard evidence they have against him. That's not a crime. And I think the other thing that Mr. Gary brings up and the court should consider, because it's part of 17-6-1, is the economic impact, not just to my client, but this case in general. The court, in its discretion under that code section, is allowed to consider a wide variety of factors. And what the government is doing here in this case is sending a message to the music industry and the entertainment industry in Atlanta that is going to have a massive chilling effect. Atlanta has become, over the last several decades, a hub in the United States for the music industry, for the entertainment industry, and it's created a tremendous amount of jobs and income and opportunity for young inner city youth. I would argue to this court, it's actually prevented a lot of crime. And what the message that the district attorney's office is sending to our community and to our country is that you better not come to Atlanta and make rap videos, because we're going to use those against you in court. And we're going to create a chilling effect on the First Amendment. And we're going to push out this tremendous, beneficial economic wave that has blessed our city and blessed our community.
He said, yo, okay. Let me, for y'all that don't know, once you start extorting people, you're gonna get hit with RICO. If you are extorting anybody, you're gonna get hit with RICO. You know why? Because extortion came from the Italian mob. When you start extorting people, you are officially telling the feds and whoever that you are a mobster. Extortion is mobster behavior. Don't go out here acting like a mobster if you not ready for mobster consequences. Don't go out here acting like a mobster if you're not ready for mobster consequences. A good friend of mine's told me that. Salute to him. It's about to be a very real reflection. I ain't gonna hold y'all, man. Please make sure y'all smashing the like button. Let's get these likes up, y'all. Let's get these likes up. Subscribe to the channel if you're new. We're gonna proceed. I'm gonna be skipping around this video though, because it's pretty long. And I ain't got time to be on here long. I'm not gonna hold y'all. But let's proceed, y'all.
They're sending a message to every young kid today in the city who hopes to grow up and become a successful musician, that whatever you go on YouTube and the internet and create as your art form, you're gonna have that used against you later. And that is a shame on them. That is one of the greatest things that has blessed our city and our community and our state in the last 2 decades. And Your Honor should consider that in granting my client a bond, a reasonable bond. Thank you.
All right, thank you very much, Mr. Abbott. All right, counsels, based upon the proffers that have been made at this point in time, I do believe that Mr. Kendrick is a threat to witnesses and likely to commit other crimes and risk of flight. For those reasons, I'm going to deny bond at this point in time. Mr. Kendrick, since I've denied your bond, though, the earliest trial date that I have at this point in time, where I've set the other persons under this indictment, is the 9th of January of 2023. So Mr. App will talk with you a little bit more about that. And Mr. App, if you should file any other additional motions to represent your client, if you would be so kind as to send copies of those to Mr. Chamberlain and Mr. Kearns, the court staff, as well as the court, since we're not an e-file party, okay?
Of course, Your Honor.
All right, okay.
Okay. By the way, Gunna is not gonna have another appearance in court till 2023 as well. Y'all know that, right? Gunna too. Gunna is also in 2023 as well. I want y'all to understand that as well. Yak Gotti once again did not tell on anybody. Yak Gotti made up a story to tell the police because he was trying to throw them off. Yak Gotti never told on anything. Niggas is reaching. You know what I'm saying? Niggas is reaching. If you give the police a story that's not real in order to throw them off, that's not snitching. That's trying to be strategic so niggas don't get locked up. That's not snitching at all. So that's nowhere near snitching. But niggas is gonna run with narratives, but they not telling facts. I'm just saying. Yak Gotti did not tell in 2015, bro. Yak Gotti gave them a fake story to throw niggas off. That's not snitching. That's strategy. I'm just saying. But let's proceed, y'all.
Any other business, sir, you may be excused. All right,
Thank you so much.
All right, thank you, sir.
You get charged with lying to the police is not snitching. I want y'all to know that, though. You know that, right? That's not snitching at all. When did that become a snitch thing?
Huh? I'll just put apt.
Definitely not a good strategy. I could agree to that. But the man did not tell. smash that like. I'm about to skip through some things because I know we ain't about to watch these niggas run through papers and not say shit. That's number one. That's what we not finna do. Hold on. Let's jump around a little bit.
All right, Mr. Geary, ready on that one, sir?
Your Honor, ADA Demetrius Smith is going to be handling that bond motion.
All right, Mr. Smith, you ready, sir?
Yes, sir.
All right, hang tight 1 second, okay? All right. All right, good morning, counsel and industry parties. We're here on the record in the matter of the state of Georgia versus Durante Beebe in 22 SC 182273. Good morning, Mr. Smith. Good morning, Mr. Partridge, and good morning, Mr. Beebe. Mr. Partridge, would you like to waive formal arraignment? Otherwise, have the court enter a not guilty plea on behalf of your client, and for you to have at least 10 days to file motions upon the receipt of discovery?
Yes, Your Honor, that's what we're asking today.
All right, I will go ahead and authorize that and order that. Okay, you also, Mr. Partridge, filed a bond motion on behalf of your client. So at this point in time, if you wish to proffer those factors under ILA that or any other factors I need to know about, so I can go ahead and make a bond determination after hearing from Mr. Smith, okay?
Your Honor, with regards to the bond, I believe former counsel filed bond. I just got onto the case last week. Judge, so I was actually going to ask the court if the court would actually allow us to reset the bond portion of this so that I may get a little bit more skin in the game, so to speak, and come up to speed with the issues surrounding Mr. Beebe. And I've informed him of the same, Judge.
Okay, all right. Let me confer with Mr. Chamberlain as to the earliest date that I can do that. I'm just going to tell you in honest candor that I have very limited spaces given the fact that we're still laboring under the pandemic, and I have I can only have Zoom availability because I have to compete with my other 30 colleagues from 2 courts and I'm a probate judge. So let me see what I have available, okay?
Yes, Judge.
Just bear with me a second.
Y'all need to be violating that like button. That like button should be getting violated. There's no reason why there's not a bruise on the like button. The like button should be bruised up from head to toe. Or should I say from thumb to the base of the hand. Respectfully, y'all need to be assaulting that like button a little bit better. Can't hold y'all. Can we please violate that like button?
Mr. Smith, I'm sorry, Mr. Partridge, the earliest date that we have is the 18th of August at 9 a.m.
Understood, Your Honor.
All right, we'll go ahead and set you for that date. If I have anything open or comes available, we'll certainly contact you. Prior to that, Mr. Geary or Mr. Smith, I'm sorry, Mr. Smith, does that work for you, sir? That works for me. Yeah, all right, 18 August at 9 a.m. Mr. Partridge, you should file any other additional motions on behalf of Mr. Beebe, now and in the future. Please include myself, Mr. Chamberlain, and Mr. Kearns in your communications, as we are not an e-file party, okay?
Yes, Your Honor, will do.
Hang tight 1 second.
Yes, Judge.
Oh, and also, Mr. Partridge, I will go ahead and just kind of tell you that right now the date for trial.
Man, what the hell they got going on, man? The cameraman is ass. Hold on, man. I think we got something. Here we go. That's Thug in the top right corner, by the way.
Do we have the petitions for Mr. Scott?
That is Thug in the top right corner.
They're not on the side of you? On the other side. You may have given them back to me.
No, I may have given them back to you, sir. That's what I'm
They're
saying.
not there. They're here. Right there. Mr. Scott?
Yes. Thank you, Edward. All right. All right, good morning, counsel and industry parties. We're here on the record in the matter of state of Georgia versus Michael Scott in indictments 15 SC 138728 and 15 SC 136331. These are probation revocation matters. Good morning, Ms. Willingham, and good morning, Mr. Raffoff, and good morning, Mr. Scott. Okay, as I understand it, these are going to be stipulated revocations. What is the state's recommendation in position number 8?
Your Honor, the state's position on both 8 and 9 is actually going to be to revoke the balance. It's 25 days remaining on each case, and we're okay with those cases running concurrent as they did originally as well.
Okay. All right, Mr. Raffoff, is that your understanding?
Yes, sir.
All right, there's Mr. Scott, good morning, sir.
Good morning.
Sir, did you have an opportunity to speak with Mr. Raffoff concerning these two aforementioned revocation petitions in 15 SC 138728 and 15 SC 136331?
Yes.
All right. Do you admit that you violated the terms and conditions your probation is set forth in paragraph 4 of each of the aforementioned petitions?
The case was a hearsay case.
Sir, I can't hear you. I apologize. Do you admit that you violated the terms and conditions of your probation as set forth in the petitions?
Yes.
Okay, all right. Based upon the petition and the negotiation and your acquiescence, I will go ahead and follow your attorney and the state's recommendation in this case and revoke 25 days on each particular indictment ending in 8728 and 6331. I'll revoke 25 days, which is the balance, and at that point in time, close the case. Okay. That's to both matters. Anything else on behalf of the state or the defense? Mr. Raffoff or Ms. Willingham?
Nothing further.
All right, that'll be the order of the court. All right, so Mr. Scott, you are, I'm going to release you at this point in time. And if there's something else holding you in, then certainly you have to address that. But if not, then this should resolve these two probation matters for you. Okay?
Oh, this nigga go.
Thank you, sir. You can be released at this point in time.
I don't know what that means. I'm gonna give you the G stack with you right now. I don't know what the fuck that means. I can't hold y'all. I don't know. I ain't gonna lie. Salute, man. That boy going home. Yeah, that nigga going home. This nigga ain't got no real charges. Oh, that nigga might get smoked when he come back outside though. That's what y'all gotta realize, man. YSL got beef with a lot of niggas out there that just came home. There's some real steppers that just came home in Atlanta. If you know, you know. So niggas might fuck around and get clipped out there after they get released. I'm not gonna hold y'all. If you know,
Lieutenant Dooley, let me know when you get Mr. Kendrick back.
He's in, sir.
Say again? Oh, he's in N506. Is that him?
Correct.
Okay, thank you. All right, Mr. Kendrick, we're back with you. We need to put something else on the record. So your attorney's here, Mr. App, and so we're gonna just put a couple other things on the record. Yes, Mr. Geary, go right ahead.
Judge, I want to reaffirm everything I told the court prior, including the prior conviction for attempted murder. The one thing I want to say that I did misstate when I told the court that he had a cell phone in the jail, I confused him with another inmate that's on this calendar. That does not apply to Mr. Kendrick. Everything else does. The possession of a weapon by a convicted felon, those things, but possessing the cell phone in the jail after the arrest on this case does not apply to Mr. Kendrick, and that was a misstatement on my part, and I wanted to clear it up as soon as possible.
Okay. All right, well, given that, Mr. Geary and Mr. Apt, I'm still gonna leave him in a no bond status, based upon what's been proffered thus far.
I understand, Your
But I
Honor.
appreciate you clearing that up and your candor with the court as well as with opposing counsel, okay?
For the record, Your Honor, I appreciate Mr. Gary's professionalism and ethics always. We're all human.
Okay, all right, thank you, sir. All right, okay, Mr. Kendrick, you can be released at this point in time, okay?
All right, have a nice day, Judge.
All right, thank you. All right, Mr. Hudson, where are you?
Yes, sir, I'm right here.
Okay, you can bring your client up, Mr. Walter Murphy. Mr. Murphy and Mr. Hudson, come on up.
This nigga like they just brought that nigga in. What the fuck? Yo, where you shoot at, champ? But y'all just arrested this nigga or something? Oh, y'all ain't got no. Y'all just put that nigga in the same clothes y'all arrested him in. I don't know. I can't call this. Son came straight from the crib, nigga. Yesterday. Jesus Christ.
Thank you so much. All right, good morning, counsel, interested parties. We're here on the record in the matter of the state of Georgia versus Walter Murphy and 22 SC 182273. Good morning, Mr. Hudson. Good morning, Counsel for the state. Which one of you is going to do this particular bond, arraignment and bond? Is that Mr. Geary or
I'm going to handle that,
Mr. Smith?
Judge.
Okay, all right, Mr.
If I
Geary.
can, Judge.
Okay, good
He's
morning.
now been incarcerated, I think, for minutes.
Yeah, he turned himself, as I understand it, did your client turn himself in this morning?
Yes, sir.
Okay, Mr. Hudson, would you like to otherwise waive formal arraignment, enter a plea of not, have the court enter a plea of not guilty on behalf of your client, and you otherwise have 10 days upon the receipt of discovery to file any motions?
Yes, sir.
Okay, all right. Is it your desire to have the issue of bond? Did you file a bond motion, sir? And when, if so, when did you do that?
I did, yeah, I filed it yesterday
Okay.
to make sure that once we was able to confirm that Mr. Murphy had a warrant, I was ready to file a motion for bond.
Okay. Is it your desire? I don't know if I'll be able to have it today, but if Mr. Geary, you're otherwise ready to have a bond on Mr. Murphy since he did turn himself in today?
Not at all, sir. I'm not prepared for that, sir.
Okay,
Young man, respond to that.
sure. But I mean, but the state does get 10 days
I
from the
understand
filing,
that.
from the filing of the.
Bro, why did the nigga lawyer sound like a good trap rapper, nigga? Don't this nigga sound like he was on don't that nigga sound like one of them niggas that was on one of them old Young Jeezy records, man? What was them niggas' names, man? I think he made a song called PSA and it had these niggas on. I can't remember them niggas' names, man. He definitely sound like one of them niggas, bro. He definitely sound like an Atlanta trap mixtape rapper. Whoever this nigga is, that nigga is a reformed trap rapper, nigga. There's no way. You hear this nigga voice, I think it's like he sold wild work. What is you talking about? Man, 3.5s. He sound like he sold mad work. What is you talking about, nigga? Ain't no way you supposed to be a lawyer, nigga. Nah, bro, I don't believe it. Let's proceed, man.
Of the motion. Okay, so, all right.
Judge, with all due respect to county, the state saying they're not ready for bond, but they came with a 28-person county indictment. Imagine being Walter Murphy at home at work since he don't get out of prison and he gets slapped with an indictment he know nothing about. And now he had to kiss his fiance, his 3 children goodbye, and he being accused of something he's already pled to from 2015. He just got out of prison, got a job. And the state not ready? Well, how long were they ready when they put this sham indictment together against this man? So I'm ready, Judge. With all due respect, Judge, I'm ready at your court's disposal. So whenever date you said, I'm okay.
Nah, this nigga sound like he low on hash browns, nigga. Fuck is you talking about, nigga? This nigga freestyle game is off, nigga. Nigga, you sound like you trying to build your freestyle game back, but you kind of slipping, Chan. You stumbling all over the place, fam. You did get your words right, fam. This nigga sound like he was missing a hash brown in his breakfast this morning. I don't know, fam. You dig? This nigga's wilding. You could tell this nigga was definitely out here trapping, nigga. There's no way in hell this nigga just was an overnight, you know what I'm saying, lawyer and shit. Nah, you was trapping, champ. You was definitely hired, nigga. You was a street lawyer. You definitely a street lawyer, nigga. Well, let's proceed, though.
But the state saying they not ready, and they put together a blind indictment, they always should have been ready.
Okay, Mr. Chamberlain, when's the next available date that we have for a bond? We could do a bond hearing for Mr. Murphy.
Unfortunately, it will be August 18th, unless new instructions otherwise.
Let's see if we can find something.
And thank you, y'all. I can waive his presence if need be.
Hang tight.
I trust my client trusts me.
We're gonna go ahead and let me see if I can find something, okay?
While Lieutenant Dooley is present, ask her. June 14th, enough.
Oh, hell no.
Okay.
45 degrees.
All right, I will. Lieutenant Dooley,
Yes, sir.
is it possible to add Mr. Murphy to the calendar on the 14th of June, madam, for next week? For that Zoom calendar, do you have space for me?
I actually don't have the calendar in front of me, Your Honor. Hold on, let me see if I can find it electronically.
I'll check. I mean, I'll stand fast, and you could check for me, please.
Will do.
All right. Okay, we're gonna wait one on that one, folks. Just give me a second.
Thank you,
And we'll see if we can get him on for the 14th.
Oh, somebody gotta reflect. Don't tell me what to do, champ. Time you out, nigga. Take time to reflect, nigga. Put on them suede thong slippers that you left in front of your grandmother's wall in her basement and reflect, nigga. Fuck is you talking about? Press play. Eat Frank, nigga. You told me to press play, nigga. Eat Frank and play with the bun. Fuck is you talking about, nigga? Reflect.
Your Honor, it looks like I've received one email from Mr. Chamberlain regarding one defendant for that calendar. So yes, you can add.
No. So I'll look for another email. That's one of the emails I sent maybe 2 days ago. And there's one I sent a while back. You may need to search up email.
When did you send it, Mr.
I
Chairman?
have to get into my email.
Okay.
To see when I sent you the first time. That's the issue.
When is it? 5-4. Found it.
Okay. So,
Yes, sir. You can still add him.
Okay, so we can add Mr. Murphy?
Yes, sir.
All right, we'll send you an email, or Mr. Chamberlain will be in touch with you about that. So we'll go ahead and add Mr. Murphy. Okay, all right, so Mr. Hudson and Mr. Geary, I will set Mr. Murphy for next week for the 14th of June to have a bond hearing, okay?
Thank you. It's a Zoom calendar, Judge.
It will be a Zoom calendar.
Thank you, Judge. I appreciate it. Thank you, Ms. Geary. Mr. Chamberlain, I really appreciate you.
Okay, all right, unless there's anything else,
That nigga definitely
we will
about
see
to
you
work
next week,
after
okay?
this. That lawyer is definitely pushing weight.
I think it's 2 weeks.
2 weeks, yeah, 2 weeks.
All right. Oh, man. Let's skip around. We got to skip around. That shit too long, man. Pause. You got to skip around a little bit.
Not be a good date for me. The 5th is a Jewish holiday. It is not a date on which I will be able to attend court. So I would ask the court to consider another date.
The 10th. October 10th.
October 10th sounds great.
All right, October the 10th it is. Mr. Brown, your attorney will get you ready and otherwise prepare you before that date. And counsels, if you should file any additional motions, I just like to remind you, since the court is not an e-file party, to send copies of those motions to Mr. Chamberlain as well as the court staff attorney, Mr. Kearns, okay? All right,
Yes, Your Honor, there is a motion presently outstanding. A Jackson Dano.
I'll hear it on the morning of trial, madam. Okay?
Morning of trial. Court, please. Thank you.
You bitch sound like a delicate owl. How the fuck you sound like that, my nigga?
And I say that, Ms. Levinsky, you look kind of shocked, surprised, but
that bitch sound.
it is that matter that I can take.
That bitch sound crazy, don't she? I know.
And given the fact that I don't have a lot, as you can see, trial space available, since we're still available.
Very wicked witch.
That's why.
Get you.
I'll just hear it the morning of trial.
I would say that it is probably a fairly lengthy motion.
Okay, well, if we can find or carve out some time for a motion, or you can do it before then. Mr. Chamberlain, do we have any Zoom availability for a motion?
That bitch definitely sound like a headmaster at Hogwarts. That's a fact.
Let's go to some. Do we have our closes? Let's put it on one of those days.
Need wild water. That's a fact too.
Okay. All right. And all right. Any Thursday.
She sound crazy, man. This nigga gonna lose because of this bitch alone. Real talk.
How about 22 September?
The word of my mother, nigga. You niggas is getting them. All them niggas getting locked up, champ.
Okay, I'm sorry. You're right. It is the 20th. Is that right? It's 20 September.
Yes, 20 September. Let me see what else I have.
Come on, champ.
Why?
20th?
Yes, the 20th. Why?
All right. How's 20 September, folks, for that Jackson Down motion, madam?
Sounds great. Thank you, Your
All
Honor.
right, Mr. Miller, does that work for you, Ms. McCauley?
Nah.
All right, I'm gonna set it for 20 September at 9 a.m. Okay, we'll do that via Zoom. Okay.
Thank you, Your Honor.
All right.
You got a free lawyer from Bookings. Fuck is you talking about, nigga? You got one of them trash ass free lawyers, or you ain't got shit. Nigga, you can't pay for shit. So now you gotta use a free lawyer. Fuck is you talking about, nigga? This lawyer is gonna make sure you get locked up, nigga. Oh man.
Your Honor, sorry. It's a Jackson Dano. I would ask that it be heard in person.
I can't, madam. I don't have the availability and space for me to do that. I can either only have Zoom or bring over in person. I don't have that ability on that day.
Court pleases. Thank you, Your Honor.
Well, yeah, look, we all got to work within the confines we have, Ms. Levinsky. I appreciate you being patient with us, but this is the best we can do under the circumstances now. Okay.
As the court pleases. Thank you, Your Honor.
Okay. All right. So I will set it for the 20th September.
Met Gala, nigga.
See you soon. Okay. All right. Anything else, madam?
Fuck y'all find
No,
this bitch.
thank you, Your
Okay.
Honor. I believe that concludes my business. May I be
All right,
excused?
madam. Yes, you and your client may be excused. Thank you very much.
Thank
Your
you.
Mary Poppins sounding ass fuck up out of here, man.
Yes, sir. You may. All right.
Nah, man, that nigga going to jail. Fuck is you
Jack,
talking about?
Greg, just so you know, I forgot to turn my camera on, but I was listening.
All right, Ms. McCollum, we got you. You got the 20th of September for the Jackson Deno motion and 10 October for trial.
10 October for trial, and the Jackson Deno is via Zoom.
Yeah, on the 20th of September at 9 a.m.
I got you. Thank you, Judge.
All right, thank you, madam.
All right, bye.
We is the thug. We gonna get to this thug shit though. We gotta skip
Yeah,
it
can you
round.
bring out Ariel Young, please?
Your Honor, he's on fine.
Okay, all right. Hang tight 1 second, okay? Thank you. Let's do 21 September, okay?
Yes, sir.
Ms. Fagan, does that work for you, ma'am?
Well, Your Honor.
Skipping.
He has children who are dependent upon him for support that all live
We
in
need to get to
Atlanta.
this dumb shit.
In
Fuck all the dumb shit.
At the apartment complex where the accused was arrested. After the officer interviewed the accused, the latent print that had been found in the victim's vehicle was determined to belong to the defendant.
All right, so what we see here is just otherwise cell members. We need to get to thug. We need to get to the leader of the young slime life. Hold on, man. We gotta get to it. Where is it?
Solid 2.5.
Hold on, let me see. You're gonna get to that in a second. I guess we almost there. Hold on.
Morning, council's interested parties. We're here on the record in a couple of matters. The first one being the state of Georgia versus Shannon Stillwell in indictment 22 SC 182273. Here for state's notice of conflict of defense counsel and arraignment and bond. Mr. Sharp, good morning, sir.
Good morning, Judge.
Okay, all right. I see you've been relegated to the cheap seats, and the fact that Mr. Steele and his entourage have taken up their seats. Would you like for us to provide you a seat?
I'm
Or
fine.
you could right there?
I'm fine here.
Okay, all right, okay, no problem. All right, just wanted to just, don't want you to feel you were left out. All right, and then the other position is the state of Georgia versus Jeffrey Williams, 22 SC 182273. Good morning, Mr. Steele, and good morning, Mr. Adams. And
Good morning, Judge.
all right, sir. All right, and we are here on the state's motion to disqualify defense counsel and for arraignment and bond. Is that correct? All right. Okay, all right. All right, let me first make sure that I have the format. Is there anybody else I was missing? So I just want to make sure I have. Mr. Williams, can you, all right, I'm going to mute you at this point in time, but we got you. All right, and then Mr. Stillwell? All right, sir, I see you on the platform. Thank you, sir. Okay, who is in S214? Violetta, can you unmute S214, please?
Sure.
All right, sir, in S214, what's your name?
Scott.
I'm sorry, one more time?
Mike Scott.
Maybe Mr. Rapoff's client, Judge. I think that's how they resolve.
Mr. Scott, we resolved your matter. You're free to go.
Sit back to get an understanding of what's going on.
Say again?
I was sitting back to get an understanding of what's going on.
He can't do that today. He said he's gonna come out and see you, okay?
Who?
Mr. Rapoff. Okay, he's gonna come out and see you, but at this point, I'm gonna excuse you for the day, okay? All right, thank you, sir.
Nigga said, bounce, get up out of here, champ.
Mr. Glenville, I think mine got unmuted again.
I'm gonna keep you on mute because I can't compete with the background noise from your location. So I'm gonna unmute you, okay? If we need to talk with you, we'll go ahead and unmute you, all right?
Yes.
All right, no problem. All right, before we go ahead and get started, folks, I've had the opportunity to read both the state's motions as it pertains to Mr. Shart and Mr. Steele. And I've also had a chance to take a look at the responses that were filed on behalf of Mr. Steele as well as Mr. Shart. And I stated you can take it any way you want, but I think that if I can frame just generally your issue in this particular circumstance for the state and maybe the defendant's position on it. As it pertains to Mr. Steele, you're saying that there's a violation or there's a potential violation of 3.7, which is lawyer as witness.
Your Honor, we're withdrawing the 3.7 claim today.
Okay.
And Mr. Geary is going to explain
Judge,
that.
I'd like to explain that to the court.
Okay. All right. Well, go ahead.
Quickly. We have notified Mr. Steele that I personally interviewed the officer previous to us making the claim, and the claim seemed solid. As we further investigated concerning the hearing today, it became evident that the officer truly believed the statement that Mr. Steele, quote unquote, confessed. However, the rendition of what the officer went through, we don't think that legally qualifies, and we're not going to support that in this motion, and we're withdrawing that in this motion. The officer did speak with Mr. Steele, but the interpretation of what occurred is different, and we're coming in on the side that there was no confession given the completion of our investigation of that matter.
All right, so you're satisfied you will not otherwise
He's off our witness list.
require Mr. Steele to be to testify or be part of any foundation that.
Correct, sir.
Okay, all right. Mr. Steele, any objection to that? They're going to withdraw that particular issue as it pertains to as it pertains to lawyer's witness 3.7.
No, Your Honor.
Okay, all right. Madam, I apologize. Your name? I apologize.
Lizzie Rosenwasser.
Miss Rosenwasser, I can't see you without your mask, so
Here we go.
okay, now I see. Okay, all right, thank you, madam. All right. All right, and Mr. Smith, again, good morning. But I have all three of you now. Okay. Okay. All right. So that having been settled, that issue, at least as it pertains to Mr. Steele, the 3.7 issue's been withdrawn. You still have 1.7 and 1.9, and I guess you're going to make argument on that particular issue, and to that effect. Is that correct, madam?
Yes, Your Honor.
As well as, is that the same basis that you're moving to disqualify Mr. Sharp?
Your Honor, to clarify for the record, we are only moving to disqualify Mr. Steele. What we filed for Mr. Sharp was a notice of conflict. We believe that all of Mr. Sharp's conflicts could be waived. We are asking today, and I do plan to go into this further in my motions for both motions, we are going to be asking today to have all the affected parties, if they wish to, come in and waive those conflicts on the record. While we do appreciate the written waivers that Mr. Steele has submitted, we believe that to ensure that the record in this trial is perfect and has no grounds for appeal, and I will go into this further in the motions because we do still believe that Mr. Steele is conflicted. However, we believe that although Mr. Sharp currently has a conflict, that conflict could be waivable. So at this point, we would ask the court to inquire into that conflict because we do believe that Mr. Sharp's conflict, as it only affects a former client, may be a waivable conflict. At this point, a conflict exists, but that conflict could be waived under 1.7b, whereas we do not believe that Mr. Steele's conflicts are all waivable.
Okay, all right. All right, well, given that, then, madam, I'll go ahead and let you proceed, and then I'll let Mr. Steele respond if he should so desire, because it appears that looking at 1.7, and that reads as follows: a lawyer shall not represent or continue to represent a client if there's significant risk of the lawyer's own interest or the lawyer's duties to another client, former client, or third person will materially and adversely affect the representation of the client, except as permitted in Rule 1.7B. And
God damn, nigga, read. Can we proceed, Chan? Please.
And also, the court's had an opportunity to kind of take a look at the case law that the state as well as the defense has raised in this particular situation. And I've had a chance to take a look at particular Benucci Height, that's H-E-I-D-T versus the state, Wheat versus U.S. And it appears that what brings us here is that Mr. Steele under 1.7 has already kind of, because he's the lawyer that's representing his current client, has already made that determination that he can represent his client. But it appears that the case law then shifts to a couple of things and says that that either the court can inquire about a conflict, given that this is a criminal case with multiple clients, multiple defendants, and with multiple counts on its own motion. But if you are, the state is moving, or the other party is moving to disqualify him, that there has to be a violation of one of the violations under the rules of professional responsibility, and there should be some proof to that, or at least some particular Bernocchi, and that is B-R-N-O-C-C-H-I versus Fortucci, and that's F-O-R-C-U-C-C-I 279 Georgia 460. It appears that in looking at Bernucci, that comment 15 to Rule 15, Rule 1.7 places the primary responsibility of resolving conflicts of interest on the lawyer undertaking representation. That would be Mr. Steele. A court may raise the question when in litigation there is reason to infer the lawyer has either neglected responsibility, and imposing counsel may raise the issue where the conflict is such as to clearly call into question the fair or efficient administration of justice. And then, of course, the case law directs that the to advise an objection from opposing counsel should be viewed with caution, and it can be used as a technique as harassment. So in order for you to have standing, which is one of the things Mr. Steele is raised, is that the lawyer having a conflict of interest simultaneously representing multiple defendants, which would in this case be formal representation. There must be a violation of the rules which is sufficient to serve to call into question the fair and efficient administration of justice. And then it goes on to say there's some, the Supreme Court, our Supreme Court has adopted or kind of mentioned what Texas does in Henry Robinson, where opposing counsel must provide substantiation. So I'm going to need to probably hear something on that. So from looking at Bernucci, I can raise the issue on my own, which I would have given what you said already. But what Mr. Steele is saying is that the burden is upon you, since he's already made this decision. He can potentially represent Mr. Williams in particular. So we'll start out with him to begin with, and then you can move on to Mr. Sharp. Okay.
Okay. Yes.
Okay. All right.
Your Honor, so our purpose today in raising this motion, first of all, and I do recognize the court's notice of the law saying that these motions can be used for harassment. That's not our purpose today. Our purpose today is to ensure that each of the defendants named in this indictment, and that includes Mr. Williams, but also Mr. Blaylock, Mr. Stillwell, Mr. Kendrick, Mr. Greer, and Mr. Arnold, all present or former clients of Mr. Steele, also have their rights properly preserved. So one of our main concerns here is that none of these waivers are on the record. We would ask, even if this court were to deny our motion to disqualify Mr. Steele, that each of these waivers be made on the record. Right now, they're written, but we believe that in order to ensure that everything is proper on the record and that we're able to create a perfect record in this case, that those defendants be brought here and their waivers be placed on the record. That's out of Taylor versus State. That's 320 Georgia Court of Appeals, 595. That's a 2013 case. In that case, defendants alleged on appeal that there had been a conflict in the lawyer, and as a result, they should get a new trial. However, because the waivers were actually made on the record by the affected defendants, as opposed they were taken in court, made on the record, the Court of Appeals found that any error was induced by the defendant's statements, and that as a result, the case was not reversible. So first of all, more than anything, we would ask that any waivers be made on the record, as opposed to simply the written waivers, which again, while we do appreciate, we believe are not sufficient to waive the conflicts, especially in light of our allegation that Mr. Williams operates a position of leadership in the gang. That's in count 56 of our indictment. We do allege that. Our concern is that as a leader of the gang, perhaps some of these individuals may feel influenced. So we would like them to be advised by this court on the record, and if they still wish to waive their rights, we believe that would at least cure some of these potential conflicts. However, Your Honor, our main concern, and I did hear the court cite to Bernucci, but our main concern is not with Mr. Steele's former representation of various clients. While we do have concerns about that, our main concern lies with Mr. Steele's current representation of co-defendant Blaylock. Mr. Steele is currently representing co-defendant Blaylock in Mr. Blaylock's direct appeal of his murder convictions. Mr. Blaylock was previously convicted of murder, a murder that occurred in 2019. That murder has then been alleged as one of the predicate RICO acts. So in this particular indictment, the murder for which Mr. Steele is presently representing Mr. Blaylock on appeal, that murder is also one of the counts alleged in this indictment.
That apparently, that case has that been returned from the court, from the appellate court already?
No, Your Honor.
That's
So
right.
the posture of that case right now is that Mr. Steele has filed an entry of appearance. We are awaiting, and I'll be handling that appeal as well. We are awaiting transcripts and a motion for new trial. There is a scheduling order on that case. I believe the hearing is set for either late this year or next year. But that is at the motion for new trial stage in the Superior Court stage. So he's currently representing Mr. Blaylock. And I'll notice that in his motion, Mr. Steele alleged that he has not spoken to Mr. Blaylock. However, I would like to advise the court that although Mr. Steele perhaps alleges that he has not received any information about this, the federal courts, so the 11th Circuit, employ an irrebuttable presumption of the disclosure of relevant confidential information when an attorney represents someone on a related proceeding. And that is out of United States versus Cordoba. That's a 2013 district court case.
Can you spell Cordoba for us, please?
C as in cow, O, R, D as in dog, O, B as in boy, A. That's a 2013 district court case out of the Southern District of Florida. But it is citing to United States versus Henry, which is 307 Fed APPX 331, and that's out of the 11th Circuit, and that's 2009. And specifically, the rule is that there is an irrebuttable presumption of disclosure of confidential information whenever there is an attorney-client relationship. Further, that court found once it is shown that the prior representation was substantially related to the current representation, then it is irrefutably presumed that relevant confidential information was disclosed. And further, an attorney's representations that he cannot recall any confidential information that would be useful in the cross-examination of a potential client does not alleviate the potential conflict because the situation might change. So I think that's particularly pertinent in regards to Mr. Steele's representation of Mr. Blaylock. And I would also like to point the court to Georgia case law, specifically the Height case that the court mentioned, the 2013 case out of Georgia. And particularly the showing required, and this is also reflected in 11th Circuit precedent for pretrial matters, there is no requirement of an actual conflict, but instead, and this is from Height at 346, accordingly, the courts must recognize a presumption in favor of an accused counsel of choice, but that presumption may be overcome not only by a demonstration of actual conflict of interest, but by a showing of a serious potential conflict. So the key language in this case, and in a lot of the cases out of the 11th Circuit and out of Georgia, is the existence of the serious potential for a conflict.
What's the potential conflict?
So the potential conflict here is similar to that which is articulated in Height, which is if we would like to come to Mr. Blaylock, and we anticipate, and I'm putting this on the record now, if defendants in this indictment wish to cooperate with the prosecution and provide testimony against other defendants in that indictment, we are willing to offer deals depending on the information and depending on the defendant. We, at this point, would be unable to offer Mr. Blaylock any such deal because the representation of Mr. Williams would be a conflict. So I would like to point the court to Height at 347. Specifically in that case, the court found that because the prospects of the conflicted attorney advising the co-defendant about any deal that might be proposed by the state to secure her testimony against Height or cross-examining her on behalf of Height were rife with serious ethical problems. The trial court did not abuse its discretion when it determined that the conflicted attorney's representation of both the co-defendant who had previously been indicted with the defendant would materially and adversely affect his representation of the main defendant. Additionally, Mr. Steele actually cites to Lewis versus State as well in his brief. And this case is very different from Lewis, but Lewis, which actually found that disqualification was improper because there was not basically the conflicted firm did not actually possess information about the witness. But Lewis even recognized the serious potential of conflict rule. In Lewis, the court recognized that there was a risk, but in Lewis, there was not a significant risk. Here, however, there is a significant risk, and federal court has similar laws like this. So in another case that's out of the Southern District of Florida, which again is 11th Circuit, and I just point to it because it's pretty analogous to our case, it's called United States versus Gutierrez, Gutierrez, and that's 2010 out of the Southern District of Florida.
Do you have another citation or feds?
Yes, Your Honor. The one I have is Lexus, so I hope that's sufficient. It's 2010 United States District Court, Lexus 99424. But it does cite to law that will hopefully be, that is out of the Fifth Circuit, which of course became the 11th Circuit. And specifically, the court found that an attorney cannot advise. So in Gutierrez, there was.
Spell Gutierrez for us again for
yes, Your Honor.
Myself and for Ms. Weaver.
Yes, Your Honor. G-U-T as in tie, I-E-R-R-E-Z.
Thank you, ma'am.
Now in Gutierrez, there was an attorney and he previously represented the cousin of a defendant. But the cousin of the defendant and the defendant were targeted in the same federal investigation. Although the attorney never officially represented the cousin did hold that attorney out to be his attorney. For instance, he gave business cards of that attorney to federal investigators. But essentially, that's actually less representation than what we have here with Mr. Steele and Mr. Blaylock. Mr. Williams and Mr. Blaylock by Mr. Steele. And specifically, the court in Gutierrez found that there was a conflict here. And first of all, the court noted that, citing to Wheat, for a court to find a potential conflict of interest, both clients do not need to be charged in the same indictment or subject to trial in the same proceeding. Further, and this was citing to the Wheat case that the court mentioned earlier in this hearing. So further, the court in Gutierrez again mentioned that irrebuttable presumption of disclosure of confidential information wherever there is an attorney-client relationship, and that once it is shown that the prior representation was substantially related to the current representation, then it is irrebuttably presumed that relevant confidential information was disclosed. Now, specifically, the court found that there was a serious potential for conflict here, finding that this attorney should be conflicted because, and this is quoting the court at page 14 of that opinion, moreover, Mr. Mitchell, the conflicted attorney, cannot adequately advise either of the defendant or his cousin about their option to cooperate against the other. And that's citing to Beatty, B-A-T-Y, versus Balcom, B-A-L-K-C-O-M, 661 F3D 391. That's a Fifth Circuit case, 1981. Of course, that later became 11th Circuit precedent. And specifically taking the quote from the Beatty versus Balcom case is the conflict of interest before trial alone would be sufficient to grant that motion, because had the attorney not been facing a conflict of interest, the attorney might have been able to negotiate a plea agreement on one defendant's behalf in return for becoming a prosecution witness against the other defendant. And I also want to point to another quote out of that case, which I think is relevant for this hearing. And this quote is, "The court may refuse to accept the waiver," such as what we have here between, there is, of course, a written waiver on the record for Mr. Blaylock. "The court may refuse to accept the waiver where necessary to ensure the adequacy of the defendant's representation, to protect the integrity of the court, and to preserve the trial court's interest to be free from future attacks over the adequacy of the waiver and the fairness of the trial." And that's citing to U.S. versus Almeida, A-L-M-E-I-D-A, 341 F3D 1318, and that's 11th Circuit Court of Appeals, 2003. So here we would argue that it's very...
I ain't gonna hold y'all. Shorty got a goddamn encyclopedia's worth of shit right now. Like, what the fuck? This shit crazy, man. This bitch got an encyclopedia's worth of shit. Like, god damn. 88, 83, Roe versus Wade, shit like that. Like, damn. Jesus Christ. I mean, I know it's court, but goddamn. Let's proceed, man. Yeah. They giving out deals. They about to start giving niggas deals. So somebody gonna tell, my nigga. Somebody's telling, nigga. It ain't no way around it, nigga. They about to help niggas now. They about to give niggas deals. Oh, man. It's about to get nasty, y'all. But let's proceed.
It's very similar. In this case, we believe that especially Mr. Steele's, and to some extent his representation of his former clients, however, we believe a waiver on the record may be able to cure those conflicts. However, we would of course have concerns that even with those former clients on related proceedings, should they choose to testify against Mr. Williams or anyone else, Mr. Steele might be conflicted in his ability to cross-examine those former clients. But particularly,
The court had a question in terms of, like, several of these clients, Arnold, Greer, and Blaylock, all have predicate offenses. Like Arnold is Act 11, Count 1. Greer is Act 108 of Count 11, and Blaylock is Acts 74 to 76 of Count 100. Wouldn't that be a potential issue if I'm looking at potentially a resolution or some other issue related to this case, wouldn't that pose a potential or an actual conflict?
Yes, Your Honor, it absolutely does. And that's the next part of my argument, because I just wanted to start with Blaylock because our biggest concern is that he is currently representing Mr. Blaylock. He is Mr. Blaylock's attorney of record. Mr. Blaylock, although he signed a waiver through another attorney, Mr. Blaylock is actually unrepresented in this case. And the only representation that Mr. Blaylock even has right now is Mr. Steele on his appeal. And as the court, I'm sure, is aware, sometimes with these appeals, we can work things out, especially if there is a pending case. I'm not saying we definitely will. It would have to be if Mr. Blaylock were to say, hey, we'd like to cooperate, but he can't even do that because of this conflict. And so that's why we started with Mr. Blaylock. I would also like to advise the court in terms of these present conflicts that we're discussing. Mr. Steele is also currently the counsel of record for Mr. Quantavious Greer in case number 10 SC 92020. And we certainly appreciate Mr. Steele bringing this to the court and the state's attention. As I noted in our original motion, we were trying to file that as soon as we could to make sure that, save Mr. Steele from any if disqualification is warranted, which we believe it is, we wanted to get that out there as soon as possible to avoid any kind of gamesmanship. But as soon as we learned about that representation of Mr. Greer, we did look into that. And we noted that Mr. Greer is actually, he was convicted of murder. That case was reversed. The state will be trying that case again. That case is presently before this court in a separate case. That case is not related to the present indictment, but Mr. Steele is still Mr. Greer's counsel of record. Should Mr. Greer wish to cooperate, perhaps negotiate some sort of resolution to both of his cases, that would certainly create what is very obviously the serious potential for conflict that I've described. So that's another one. Also, as the court just raised to me moments ago, we do think that there are serious problems with the former clients based on especially the federal case law that I've discussed, where there is this irrebuttable presumption of disclosure of confidential information whenever there is an attorney-client relationship. And when that issue is substantially related to the current representation, which obviously it is, these counts are the predicate acts for the present case. We think that there is an irrebuttable presumption that relevant confidential information was disclosed. So, and again, also I'd like to point the court's attention to another case out of Georgia, the Georgia Court of Appeals case, Edwards versus State, 336, Georgia Court of Appeals 595, parallel site 784 SE 2D 924. That's a 2016 case. And in that case, the defendant's attorney had formerly represented the victim's mother in a previous proceeding. It was a child molestation case that was on trial. The court found that there was a serious potential for conflict there. And although the defendant in that case waived the conflict, the court found that the Court of Appeals found that the trial court properly declined to accept that waiver because the defendant's waiver of his attorney's conflict of interest does not always cure the problem, because courts have an independent interest in ensuring that criminal trials are conducted within the ethical standards of the profession and that legal proceedings appear fair to all who observe them. And that waiver does not work, and this goes to one of the non-waivable conflicts in 1.7c. Waiver doesn't work because his defense counsel's loyalties would have been divided by the above stated ethical duties. And again, the reason that the state is bringing these motions today and why we are so concerned is because, as the court found in Edwards, in the absence of an effective waiver of the right to conflict-free representation, and so that would include cases where conflicts cannot be waived, allowing the trial court to proceed to verdict would have created a serious potential for error sufficient to allow Edwards to obtain reversal of any guilty verdict by claiming on appeal that he was prejudiced by the conflict. So essentially here, Your Honor, to sum up my argument, basically, first of all, while we appreciate the written waivers, we believe that if the court is even willing to consider waivers to cure any of these conflicts, those waivers would need to be here in person on the record, where the defendant could confirm to this court, and this court could observe that defendant, everything around him, his demeanor. He couldn't come back and say, that's not my signature, I didn't authorize this, anything like that. We'd ask that these be on the record, where the defendant advises that he has had the consultation, he has received in writing reasonable and adequate information about the material risk and available alternatives, and he's had the opportunity to consult with independent counsel. And those rules are out of Taylor, which I cited earlier. But again, our position today is that some of these conflicts, particularly the conflict with Mr. Blaylock, and to a lesser extent, the other former client conflicts, including Mr. Stillwell, Mr. Kendrick, Mr. Greer, and Mr. Arnold, are not waivable conflicts. And I also do want to point the court's attention to our concern with Mr. Stillwell is that we believe his counsel is also facing a conflict, and his counsel is who got the waiver on this case. So there's sort of a double conflict here. But again, Your Honor, basically because we truly think that there is a serious potential for conflict, because basically should we wish to convey those plea offers, the attorney would not be able to negotiate that in return for becoming a prosecution witness against someone else, against, for instance, Mr. Williams, who we've of course alleged is in a leadership position in this gang, which is why these are particularly concerning allegations. One moment, Your Honor.
Oh, damn, that's ugly.
That's all I have for the court at this time on why we believe that this court should, first of all, request any waivers be on the record. And additionally, we would ask that this court grant our motion to disqualify Mr. Steele on the grounds of the 1.7 and 1.9 conflicts. Thank you, Your Honor.
All right. Mr. Steele, I'll let you respond, and then,
it's always the ugly bitches that do their homework, champ. It's always you feel me? Oh no, shit. What is this? Y'all see, shorty? Ooh-wee. It's always the ugly bitch that's gonna make sure that she put you away for good, champ. She don't look good, but she gonna make sure she puts you away for good. She gonna make up for it, champ. She gonna make sure she gonna make sure she throw the book at you, champ. Oh man, she do look like a very pale ant. What is you talking about? You know what I'm saying? A Bug's Life villain. That bitch look like a Bug's Life villain. Fuck is you talking about? You ever seen a Bug's Life, nigga? Shorty do look like an evil ass moth, my nigga. I ain't gonna hold you. Oh man, I should have knew that bitch was hit. The way she was doing all that homework, bitch was up night and day trying to get these niggas the fuck up out of here, man. Ooh, wee. That bitch is all types of ugly, my nigga. That's an ugly bitch, shit. I can't hold you. That bitch is hit. Yikes. But let's proceed, y'all.
And then Ms. Rosenwasser, I'll let you, if you have any other argument as it pertains to Mr. Sharp, and then I'll let him respond, okay?
That bitch look like a fucking leaf hopper, nigga. A praying man.
All right, Mr. Bullard, good morning, sir, or good afternoon at this point in time.
Oh, yeah, we have been here a while, Your Honor.
Yes.
Wait, hold on, wait. Super 6'4" says I'm smashing her. I'm gonna let you take time to reflect, nigga. You can't be out here. You too. You know what I'm saying? You too horny, champ. Pause. You too horny, champ. I'm gonna let you. You gotta sit down, Indian style. Put on your mother's suede thongs, slippers, and reflect, nigga. And look at your grandmother's wall, nigga. Look at that nice wallpaper. Reflect. Talk about you going to smash. Nah, champ. We gonna get you right, champ. That ain't smashable. Respectfully. But let's proceed, man.
First, Your Honor, I'd like to thank Mr. Geary and Ms. Rosenwasser for their professionalism and candor in foregoing the Rule 3.7 issue. We always felt that wasn't going to bear out, that there was no way Mr. Steele could be a necessary witness in this case. Glad on investigation, they see things our way. As for the Rules 1.7 and 1.9 issues, however, I know that Ms. Rosenwasser didn't quite give the court the full picture of the case or the full picture of the law. As Your Honor noted, to require disqualification, the state has to allege and substantiate a claim of an actual conflict of interest. Now, we are in a criminal case and we're talking about the Sixth Amendment context where the one's right to chosen counsel, Mr. Williams' rights to chosen counsel.
It's not absolute.
It is not absolute, Your Honor.
So I think that the case law kind of walks us through that. So let's just kind of go through that.
Sure.
I understand that he has a Sixth Amendment right to choice of counsel, but in this particular circumstance, the court has to be, you all have sought waivers, it's got waivers. That's step one. And then there are issues of whether or not there's been an ethical violation, and then the issue of whether or not there is, some type of substantiation. So let's address that.
All right. So first, I'll turn this around then. As for the waivers, Your Honor.
Do you believe that I should go ahead and hear those, have those in, given what Ms. Rosenwasser has cited, I believe it's Taylor, that would probably be the better practice for me to go ahead and have a actual on the record hearing or actually waiver. Are you in disagreement with that?
In general, no, Your Honor. There is no harm in bringing the individual defendants in, having the court inquire whether they fully understood the rights they were advised of, and whether they have actually waived the issues. There's no real problem there. I would note, however, that the rules of professional conduct describe written waivers as appropriate on consultation with independent counsel. And that's what we have here, Your Honor. We have several lawyers, each of whom have independently consulted with Mr. Steele's current and former clients, who have represented to those clients in the court and who are presumptively ethical.
I'm not in any way saying that Mr. Steele is unethical or in any way.
You gonna skip past it? I ain't got time to be here respectfully.
Stable, but in erroneous deprivation of counsel at this point, no matter what quality of counsel Mr. Williams received at trial, if he's convicted, there's no showing of prejudice for reversal. He was denied his chosen counsel with whom he has a long-standing relationship of almost a decade, his chosen counsel who's intimately familiar with his business and affairs, whom he trusts, who has advised him in a number of matters, and who's simply not replaceable, even by other competent defense counsel, because he has been chosen. And even if the court were to find a...
Are you about to get? Do you have anything else you want to add in terms of some factual predicate or anything?
Those are my, except for Mr. Williams. If you choose to remove me from the representation Jeffrey Williams, and I know he's represented on this motion by the Honorable Keith Adams, and I know he's on the screen. I have been with Mr. Williams countless days, weeks, months, and hours. I know his entire life. You want to talk about a representation of a client? That is the bond of an attorney-client relationship. Not like anything these other people.
Okay. All right. Anything else, sir? Okay. Why don't you have a seat up here, Mr. Steele? And
It's fine.
Do you have any questions you want to ask him?
We don't have any questions.
Okay. All right. Then, sir.
I'd like to respond to the argument, but we don't have any more questions.
Okay. All right. All right. You can have a seat, Mr. Steele. Thank you. All right.
I know you was capping, nigga.
Thank you, Your Honor. So briefly, in conclusion, I would like to ask the court to take judicial notice of all the exhibits that I put in with my motion. Those are all court documents, specifically just showing Mr. Steele's entry of appearance on Blaylock's case, as well as his entry of appearance on Mr. Greer's case. And I do just want to clarify for the court, although Mr. Steele represented Mr. Greer on that incident, as Mr. Steele testified to, he represented Mr. Greer on the September 2020 arrest. And of course, he was successful in getting that one charge dismissed. And that, you know, he really represented him on that. That's now a predicate act. The fact that the firearm that he had was stolen, that's become a predicate act. So it's the same incident. It's just a different crime charged. Obviously, Mr. Steele does still represent Mr. Blaylock. And our real concern here is we haven't made an offer to Mr. Blaylock because we really can't make an offer to Mr. Blaylock right now. And I will say, as officer of the court, we have discussed with at least one attorney the possibility of if a person or persons wish to cooperate with the state. We have raised that to at least one attorney so far. We, of course, plan to raise that issue in the future. And so basically our point here is that because of the position that we are in right now, Mr. Blaylock and Mr. Williams, there is a serious potential conflict there. And I want to clarify to the court, the standard pre-trial is not actual conflict. Actual conflict is the standard if someone is challenging it on appeal following trial. What it is right now is whether there's a serious potential conflict. We have shown that there's a serious potential conflict. The court documents show that on their face. And further, Mr. Steele's own testimony shows that he did represent.
The fuck, man? I don't think we want to skip over this. That's nasty.
Like to start with the same place that counsel Bullard began and point out that I am, in fact, Mr. Jackson's, named as Mr. Stillwell in the indictment, his chosen attorney. Factually, I will say as an officer of the court that I had meetings with Mr. Stillwell, as he's named in the indictment. I'll call him Mr. Jackson. I had conversations with Mr. Jackson and have met with him about the substantive charges in this indictment prior to this case being indicted. I have been meeting with Mr. Jackson prior to the state creating what they say is a conflict by indicting 28 individuals with very different substantive charges, all on the same indictment. Now, factually, what am I referring to when I say the state has charged 28 individuals with charges that have literally nothing to do with each other in creating this conflict? Well, Mr. Jackson in this indictment is charged essentially with various charges, but the two events that he's charged with are a 2015 alleged murder, where his co-defendants are Quamarvius Nichols, Demekion Garlington, and Miles Farley. Excuse me, a May 14th, 2022 murder, where those individuals are listed as co-defendants, and a January 10th, 2015 alleged murder, where his co-defendants are listed as Javaris Bradford, Justin Cobb, Diamante Kendrick, and Demise McMullen. Mr. Eppinger, whom I have represented in the past, is charged on this indictment with 3 substantive acts. He is charged with an alleged armed robbery from October 12, 2021, an alleged attempted murder, which was the alleged shooting of the officer on February 7th of 2022, an alleged conspiracy to commit murder, some allegation of something being done within the jail, conspiring to kill an individual from February 22nd of 2022. I will point out that Mr. Stillwell Mr. Jackson is not a co-defendant on any of the substantive charges that Mr. Eppinger is charged with. Likewise, Mr. Eppinger is not a listed co-defendant on any of the charges against Mr. Jackson. There is no indication at all that Mr. Eppinger is a witness, has any information on either of the murders that Mr. Jackson is charged with, and there's no indication at all that Mr. Jackson has any information on the 3 substantive charges against Mr. Eppinger, which would make him a witness. There is no indication that these 2 individuals even know each other than they're reading each other's names on indictments they're named in. The point I'm making, Your Honor, is to even get to the point where we're talking about waivers, and I will say I do have a written waiver from Mr. Jackson, who's Mr. Stillwell. But before
Do you have
we
any
even
issue with having that done on the record pursuant to Taylor?
with Mr. Stillwell, I don't have a problem with that. And he's here, and he did discuss these matters with a separate attorney previously. So, but to even get to the point of waivers, there has to be a materially adverse relationship. There's no relationship in this case. There's none whatsoever. If the state, and we talk about substantial likelihood, Your Honor, you've been doing this for a long time. I've been doing this for a significant amount of time. We see what each individual that I've represented in the past is charged with. The state might be willing to make offers with some people. If they're waiting to make an offer to Mr. Eppinger, who's charged with what he's charged with, then certainly they need to contact GPDC, which they've apparently filed an emergency motion today to get everyone attorneys, and they can talk to whomever is appointed to represent Mr. Eppinger, and I have nothing to do with that whatsoever. If we haven't, in my estimation, and I think it's pretty clear, there's no material, they're not materially adverse so as to require a waiver even to begin with. And I'm just wary, of my clients and their choice of counsel being dictated by other individuals I don't represent. So if I thought that their interests were materially adverse, I would have never gotten involved with this indictment. I don't see how in the world 2 individuals that are not charged with the same substantive acts, and for all we know, don't even know each other, could be materially adverse. I would think that to the extent that they affect each other at all, every individual in the indictment, their case would go stronger by other individuals doing well at trial with their substantive charges. So it's not a situation where there's any threat or possibility of blaming others or shifting the blame or anything like that, because again, they're not charged with the same substantive offense. So thank you, Your Honor.
All right. Thank you, Mr. Sheriff.
Yeah, this shit over with. Thank God. Sheesh. That nigga.
All right, counsel, I'm going to take just a brief recess to consider this issue, and then I'll give you some direction on where we proceed from there, okay?
Your Honor, I'm sorry if I could just briefly respond to his argument.
Okay.
Hey, listen, man. Thug ain't make bond, bro. Young Thug did not make bond. He won't be making bond. Y'all need to understand this is a RICO case. This man is the head of a RICO. I don't know how I don't know if y'all understand how serious that is, but I'll tell y'all this once, and I'm gonna tell y'all this again. You got a lot of motherfuckers out here trying to be mobsters, but are not ready to deal with mobster consequences. If you are extorting people, you are being looked at as somebody that's in a mob, because that's what the Italian mafia or Italian mob brought to the United States. Extortion. Extortion is gonna get you hit with RICO. So if a nigga like Whack 100, for example, is out in the open saying he's extorting niggas, that nigga work with the feds, bro. Because there is no way in hell that you can say that you extorting people and you're not locked up. Because if somebody says you're extorting them, you're gonna get hit with a RICO charge off the rip. You're gonna get hit with RICO. Understand? I'm just telling y'all facts. But hey, salute to the chat. Smash the like button. Subscribe to the channel if you're new. There's about to be a lot of changes to this channel, so be prepared for all the hating ass niggas that try to knock this page down. Understand, this page will never be knocked down. And there's going to be a hell of a lot of changes happening, so please be prepared, man. Please be prepared. Salute to the chat. Salute to the sniper game. I'm back in full effect, and I'm not going nowhere and never will. We run YouTube, nigga. Fuck these niggas. I'm off it, y'all. Y'all be easy. Hey, by the way, make sure that y'all go to wearetough.com right now and get you that nice Reflect merch right now as well. wearetough.com for that merch. And you can follow me on Instagram and Twitter at Clyde the Beast, man. Listen, I'm back, nigga. Fuck these niggas. Eat Frank with your mother's mouth. You feel me? I'm here, nigga. I'm here. And for any of you goofy niggas talking about some Brick Talk shit and what happened to Brick Talk, I hope that didn't happen to you, Showface. Eat Frank, nigga. Because ain't nobody doing nothing to me, nigga. My name is not Brick Talk, but I'll make a nigga join Brick Talk. Fuck is you talking about, nigga? Fuck with me, nigga. I'm out of here. Y'all be easy. Peace.
Reflect, champs.
Reflect.
Reflect.
So I'ma have to put you on timeout, sit Indian style, let you stare at that nice wall in your mother's basement and reflect, champ.
It's time to take a time out and reflect, champs. While you're sitting Indian style and you're looking at your grandmother's wall in that basement, make sure you take time to reflect, champs. And while you're doing all your reflecting, make sure you go over to wearetough.com and get your merch today. That is wearetough.com. And get your merch today.